Okay, hello and welcome to this mini lecture on COVID-19 and the law. My name is Brian Hutler. I'm a Hecht-Levi postdoctoral fellow at the Berman Institute, and I'm happy to be speaking with you today. So let's begin by recapping a story that is probably pretty familiar to most of us. So beginning in late February 2020, basically as soon as we recognized the severity of the COVID-19 pandemic in the US, state and local governments began issuing executive orders that were designed to respond to the pandemic. So Jay Inslee, the governor of Washington, was the first to declare a state of emergency in his state on February 29th. And many other states soon followed, including Florida, California, Maryland, and New York within the next week. State and local officials went on to issue many subsequent executive orders, closing schools, restaurants, and non-essential businesses, banning large gatherings, restricting travel, and requiring residents to stay at home. Eventually, all 50 states, as well as many cities, counties, territories, and tribal areas, issued executive orders of this kind in response to the spread of COVID within their communities. So because of the history of federalism in the United States, the authority to respond to a public health crisis is properly within the domain of state and local governments. The federal government's role, apart from regulating foreign travel, is largely limited to providing guidance and support. And in some ways, this system has worked as designed. State and local governments have taken the lead on fighting the pandemic in their own regions, while at the federal level, the CDC has provided information and recommendations. The Army Corps of Engineers has provided on-the-ground medical assistance, and Congress has enacted a number of economic relief and stimulus bills. Of course, the US political system has also failed spectacularly, as many states reopened too early, and Congress has allowed key relief packages to expire without renewal. And this even as the virus continues to spread in much of the country, as of late August anyway. These political failures, cast against a backdrop of racial injustice, overburdened schools and hospitals, and extreme wealth inequality, has resulted in a public health nightmare that we're still living through, I'm sorry to say. So much of this story by now is very familiar, but today I will deep dive on one specific topic: the legal challenges that have been brought against the state and local COVID responses. Some executive orders have been challenged on state law grounds, most notably the Wisconsin legislature's successful challenge to the state health department's stay-at-home order. But frequently, state and local pandemic response have been challenged under federal law, and in particular, under the protections for individual rights and freedoms found in the US Constitution. Today, I will focus on some of these constitutional challenges. Just to be clear, in our federalist system, the scope of federal authority is limited, but relevant federal law always takes precedence over state and local laws when it applies. So this supremacy of federal law is familiar when it comes to constitutional rights. We can probably all name some famous cases in which the US Supreme Court struck down state or local laws that violated constitutional rights of individuals. As a matter of legal formality, the supremacy of the Constitution holds true even in a pandemic. In practice, what this means is that individual plaintiffs have a legal cause of action against their state or local government whenever the pandemic response conflicts with their constitutional rights. That is, they have grounds to file suit in federal court. However, it has long been a settled matter of constitutional law that plaintiffs rarely win such legal challenges. When a state or local government acts in response to a public health crisis, courts have typically deferred to the government, even if the response conflicts with an individual's rights. One famous case has come to stand for this principle of deference, decided by the US Supreme Court in 1905, called Jacobson versus Massachusetts. This case involved a vaccination requirement intended to stem a smallpox outbreak in the Boston area. When the city of Cambridge sought to enforce the mandate against a Lutheran pastor named Henning Jacobson, he refused to comply and was fined $5. Jacobson appealed the fine, arguing that the vaccine mandate violated his right to bodily integrity, as protected by the Due Process Clause of the 14th Amendment. The Supreme Court held in favor of Massachusetts upholding the vaccine mandate. The court recognized that Jacobson had a constitutional interest in avoiding vaccination, but at the same time, the court also recognized that state and local governments have a constitutional authority to promote public health, which in this case outweighed the plaintiff's interest in avoiding vaccination. Although this case dealt only with vaccination, Jacobson has come to represent a general prioritization of public health over individual rights, especially but not exclusively in the context of public health emergencies. Jacobson has frequently been cited for the proposition that the government's interest in promoting public health outweighs individual rights and interests in contexts as different as patients with diminished capacity, the regulation of abortion, regulation of controlled substances, and even restrictions on residential signage. Returning now to COVID, it may seem to follow from Jacobson that state and local governments should be allowed to impose restrictions to slow the spread of COVID, even if these restrictions infringe individual rights and freedoms. But it has not exactly played out that way in the courts. In fact, many courts have been sympathetic to at least some of the legal challenges that individuals have brought against state and local pandemic response. The first group of cases I will discuss involve state orders banning non-urgent surgeries in an effort to preserve hospital capacity and PPE and to reduce the spread of COVID in healthcare facilities. While many states issued orders of this kind, some states specifically targeted abortion procedures, arguing that so-called elective abortions are non-urgent and so should be postponed indefinitely. Abortion providers challenged the state's authority to dramatically restrict their patients' access to abortion in this way, citing to the constitutional right to abortion first recognized by the Supreme Court in Roe v. Wade. The state officials, for their part, argued that Jacobson demanded deference to their judgment about how best to balance the benefits and burdens of pandemic response. But federal district courts in 6 different states, Alabama, Arkansas, Ohio, Oklahoma, Tennessee, and Texas, disagreed with these states, holding that their abortion bans likely violated the plaintiff's constitutional rights. Now, 4 different federal circuit courts heard appeals on this issue. And these cases resulted in a potential circuit split. The 6th and 8th circuits agreed with the district courts, allowing most abortion procedures to proceed in Alabama, Ohio, and Tennessee. But the 5th and 8th circuits upheld the abortion bans in Texas and Arkansas, respectively, citing to Jacobson for the idea that in a pandemic, courts should defer to state governments rather than enforce individual rights. As a result, it was nearly impossible to perform most abortion procedures in Texas for much of the month of April. That is illegal. And in Arkansas, the ban remained in effect until August 1st. These abortion cases are significant for many reasons, of course, but for our purposes today, I want to focus on the questions they raise about the relationship between individual rights and pandemic response. Should courts be deferential to state and local governments acting in response to the COVID pandemic, even when individual rights are impacted? Let's see if your answer to this question changes once we consider the next set of examples. In particular, I'll now discuss a line of cases involving the rights of religious congregations to gather for worship. So, after many states banned large gatherings and closed non-essential businesses, churches and other religious groups around the country filed suit, claiming a right to hold in-person worship services under the First Amendment's Free Exercise Clause. Many congregations argued in particular that they were being treated unfairly because they faced greater restrictions than comparable secular institutions. On the other hand, state governments again argued that Jacobson requires deference to their pandemic response, citing evidence that in-person worship services create a significant risk of a superspreader event. What is interesting here is that, again, a circuit split seems to have emerged. This time, the Sixth Circuit struck down Kentucky's ban on in-person worship, but the Ninth Circuit upheld California and Nevada's limits on church capacity. The Seventh Circuit also upheld Illinois' stay-at-home order against challenges by churches. Notably now, a challenge brought by the South Bay United Pentecostal Church of San Diego reached the Supreme Court in late May. The church argued that California's 100% limit on in-person worship posed an irreparable harm to its ability to celebrate Pentecost Sunday, which was May 31st. Because this church sought a temporary injunction on an expedited basis, the Supreme Court did not have time to fully consider the merits of this case. Instead, the church's request appeared on the so-called shadow docket, that is, the cases in which the court issues orders or grants or denies motions without full briefing and argumentation. These cases generally carry little precedential weight, but they can be very important both to the parties to the case and also for helping us get a sense about how the Supreme Court thinks about a specific legal issue. In this case, the Supreme Court upheld California's 100% limit on in-person worship, and Chief Justice Roberts published a brief opinion explaining that under Jacobson, courts ought to defer to state officials in order to guard and protect the safety and the health of the people, especially in the face of scientific uncertainty about the spread of the virus. What is really notable about this South Bay case, however, is that the decision was 5-4, as 4 justices, Thomas, Alito, Gorsuch, and Kavanaugh, sided with the church and would have granted an injunction. A similar petition reached the Supreme Court in late July. This time, Calvary Chapel, Dayton Valley, challenged Nevada's order limiting in-person worship to 50 people, even as the state allowed casinos to operate at a 50% capacity. Again, 5 justices deferred to the state government, denying Calvary Chapel's request for an injunction. But again, the same 4 justices dissented, with Alito and Kavanaugh writing detailed opinions decrying the unfairness of Nevada's rules. After all, for many casinos operating at 50% capacity, that ends up being far more than 50 total people. The counterargument, of course, which, to be clear, no justice in the majority felt the need to write, is that casinos are very different from churches, and that under Jacobson, courts should generally defer to states' efforts to protect the health and safety of their residents, particularly in a pandemic. These church closure cases leave the future relationship between Jacobson and the Free Exercise Clause very much unsettled. What is clear is that 4 justices seem inclined to support free exercise challenges to church closures. But the opinions of the other 5 justices, if similar cases were to be fully argued before the court, remains open to doubt. Okay, let me now turn to one final set of cases involving lawsuits brought by inmates and detainees demanding adequate COVID response from prisons and jails. Citing to the 8th Amendment's prohibition on cruel and unusual punishments, inmates and detainees have sought a variety of protections, including access to soap and hand sanitizer, implementation of social distancing policies and quarantining policies, and adequate treatment and testing. State and local prisons and jails, on the other hand, have argued that Jacobson requires deference and leeway in determining their policies, especially in light of the complex and rapidly changing nature of the pandemic. As before, the Federal Circuit's courts appear to split on the matter. The 5th Circuit and the 11th Circuit deferred to prison policies of Texas, Louisiana, and Miami-Dade County, while the Ninth Circuit, by contrast, sided with the inmates of an Orange County, California jail, upholding an injunction against that county and its sheriff. However, in early August, the US Supreme Court chose to step in and overrule the Ninth Circuit's decision in this case, striking down the injunction against Orange County. The Supreme Court's intervention in this case was again 5-4, but this time Justices Ginsburg, Breyer, Kagan, and Sotomayor dissented. And this time, Justice Sotomayor published a detailed dissent arguing that the courts must intervene because the jail had failed to safeguard the health of its inmates in its care. The upshot of this recent shadow docket activity is that at least 8 of the 9 Supreme Court justices do not feel bound to defer to the pandemic response of state and local governments, at least not in all cases. Justices Thomas Alito, Gorsuch, and Kavanaugh voted to strike down restrictions on religious worship, while Justices Ginsburg, Breyer, Kagan, and Sotomayor sided with inmates against jail officials. Only Chief Justice Roberts deferred to state and local governments in all 3 cases. Okay, summing up, the future of federal court intervention in state and local pandemic response remains murky. Government officials can no longer count on judicial deference under Jacobson versus Massachusetts. Going forward, government officials will need to pay serious attention to the many ways in which individual rights and freedoms could be impacted by their pandemic response. In the coming months, we should expect a second wave of COVID-related lawsuits, especially as cases involving voting rights and free speech make their way through the courts. The intervention of the courts in COVID response is, of course, problematic in a number of ways. Lawsuits are often contentious and adversarial, and they can be time-consuming and resource-consuming. They can distract from effective policymaking and pandemic response. And judicial intervention tends to be a blunt instrument, resulting in either more or less rights protection than we might think is warranted, all things considered. And yet, in our political system, individual rights and the ability to defend them in court are indispensable, a necessary check on government injustice and abuse. So that's all I have for you today. This lecture was intended to provide an overview of the federal court's response to COVID so far, and a window into future possible legal developments. I hope I may have also provided food for thought on some of the hard ethical and political problems that we face as we continue to navigate COVID-19 and its aftermath. Thanks for watching. Hi guys, I'm joining you again in late September for a brief addendum to the video that you've just watched. After the very sad passing of Justice Ruth Bader Ginsburg, her passing is relevant to the content of the video you just saw because of the analysis of the court that I provided and the likely votes for and against the Jacobson versus Massachusetts inspired policy of deference towards state and local governments during a pandemic. Much of that analysis still holds true. There remains a majority of the justices on the court who seem willing to dispense with Jacobson deference and question or second guess state and local pandemic response policies in certain circumstances. The now vacant seat on the court, if anything, just adds further murkiness and complexity to the path of the law going forward. So we shall all see together how this plays out, but wanted to acknowledge the life and career of Ruth Bader Ginsburg, who is no longer with us. Thanks again for watching. I hope you enjoyed it.